prove that they have a first case and or an ideal provision with reasonable chances of success. That would be rendered mandatory if the state is not granted. Make a final decision ground necessitates an inquiry in two grounds laid down in revision clause number 2 of 2025 without getting into the applicant has an applicable revision. Is of reference, the rest of the revision are reproduced here below. Round 1. The Chief Magistrate illegally and without jurisdiction entertained the applicant's complaint, drew up a charge, and issued summons. Round 9. The Chief Magistrate separately consulted a purported parish chief ward administrator whose findings did not confirm the response complaint and improperly relied on this consultation. Round 7 and 5. The Chief Magistrate erred in holding that a prima facie case was established against the applicant under Section 115, subsection 3 of the Penal Code Act, Cap 128. He improperly found that the response made the reasonable and probable threshold under Section 42, subsection 3 of the Master Court Act. Round 10 and 11, the Chief Magistrate wrongly found the respondent's complaint was not vexatious and frivolous. He erred in holding that the respondent's complaint was not an abuse of court process. Round 2, the Chief Magistrate improperly failed to dismiss a denied complaint on oath by the intending private prosecutors. Round 6, the Chief Magistrate disregarded Section 6, Subsection 2, Part A, Section 7, Subsection 1, Section 7, Subsection 2, and Section 7, Subsection 4 of the Electronic Transactions Act in considering the responsive video evidence. Round 8, the Chief Magistrate did not consider the context, symbolism, and constitutional protections of the words in question, thereby occasioning a miscarriage of justice. Round 3, the Chief Magistrate erred in law by denying the applicant's request to cross-examine Mazima on his affidavit in reply. Round 4, the Chief Magistrate wrongly concluded that the respondent did not breach the duty of candor. Round 12, the Chief Magistrate improperly declined to recuse himself from the proceedings. The court will now do a systematic audit of the above grounds. Round 1, whether the magistrate illegally and without jurisdiction entertained the response complaint, drew up a charge, and issued summons. This ground raises two questions for court's determination. The first question is to ask under this ground is whether the Chief Magistrate had the power to entertain the response complaint, draw a charge, and issue summons. Section 42, Section 3 to 7 of the Magistrate Court Act comprehensively sets steps to follow while instituting private prosecution. It provides as follows: 3, 4, 5, 6, 7. The preceding section highlights the procedure for initiating a private prosecution, which consists of multiple steps in which a magistrate plays a vital role. Firstly, any individual, excluding public prosecutors or police officers, who believes there is reasonable cause to think an offense has been committed can lodge a complaint with the relevant magistrate. The complaint can be made orally or in writing. If made orally, it must be documented by the magistrate. Upon receiving the complaint, the magistrate must consult the local chief in the area where the alleged offense occurred. Although this step might be bypassed if the complaint is accompanied by a letter from the chief, after ensuring the complaint indicates prima facie evidence of an offense and is not frivolous, the magistrate will formalize a charge against the accused. The magistrate then decides whether to issue a summons or a warrant for accused disappearance in court. The law cautions that a warrant may only be issued if the charge is substantiated by sworn evidence. The magistrate also has the discretion to delay issuing a summons or warrant, potentially directing the police to investigate the matter first. The magistrate plays a pivotal role in private prosecutions, acting as a gatekeeper who ensures that only serious and substantial complaints proceed to formal charges. The magistrate's responsibilities, from consulting local authorities to deciding the issuance of summons or warrant, help maintain the integrity of the judicial process and prevent the misuse of the system by addressing frivolous or vexatious complaints. Hence, the magistrate ensures that the rights of the accused are protected while providing a pathway for private individuals to seek justice. The record shows that the chief magistrate complied with the law regarding the instant case. This leaves me with the second and last question: whether the chief magistrate had the jurisdiction to entertain the respondent's complaint. The term jurisdiction encompasses a wide range of meanings that vary based on the context in which it is used. According to Black's Law Dictionary, 8th edition 2004, on page 867, jurisdiction is defined among other interpretations as follows. 1. A court's power to decide a case. 2. A geographic area within which political or judicial authority may be exercised. And 3. A political or judicial subdivision within an area. In Kasivante Moses versus Katongole Singh Marak and another Kampala election petition number 23 of 2011, court held that the term jurisdiction is not a term of art. It is a term of law. It is a term of very extensive legal import. It embraces every kind of judicial action. It confers upon the court the power to decide any matter in controversy. It presupposes the existence of a duty, constituted court with full control over the subject matter and adjudication. It also presupposes full control by the court of the parties to the subject matter and under investigation by it. Jurisdiction defines the power of a court to inquire into facts, to apply the relevant law, to make decisions, and to declare the final outcome of the subject matter under its inquiry. In Ahmed Kawoya Kangu versus Bango Agri Fred and another Supreme Court civil application number 2007, Justice Bat Katrebe, then Justice of the Supreme Court, held that jurisdiction of the court is not a matter of implication, but must be prescribed by law. In this context, I interpret jurisdiction to signify 1. The authority of a court to adjudicate a case, and 2. a specific geographic area region where judicial power can be exercised. In paragraph 5 of the complaint on oath, the applicant is said to have committed the offense of insulting the modesty of a woman contrary to section 115, subsection 3 of the Penal Code Act. In the same paragraph, the complainants allege that the offense was committed at Katonga Road in Kampala, Central Kampala. The response complaint. The authority of a chief magistrate to adjudicate cases is provided for in section 161, subsection 1, part A of the Magistrate Court Act, which permits a chief magistrate to handle any case excluding those that carry the death penalty. The alleged violation pertains to section 115, subsection 3 of the Penal Code Act, which prescribes a penalty of 1 year's imprisonment. This offense falls within the subject matter jurisdiction of the Chief Magistrate Court. Touching on the issue of geographic jurisdiction, item 14 of the schedule in the Magistrate Court Magistrate Areas Instrument 2024 shows that the magistrate areas with jurisdiction at Buganda Road, a grade 1 magistrate at Buganda Road, a grade 1 magistrate at City Hall, and a grade 1 magistrate at Law Development Center. Because of this, the matter of geographical jurisdiction is satisfied. Based on the above, it is evident that the subject matter and geographic jurisdiction align with the powers conferred upon the Chief Magistrate Court. Firstly, as outlined in section 161, subsection 1, part A of the MCA, Chief Magistrates are empowered to adjudicate cases that do not carry death penalty. The alleged offense carries a maximum penalty of 1 year's imprisonment, which is within the subject matter jurisdictional limitations of a Chief Magistrate Court. Secondly, the issue of geographical jurisdiction is also satisfied. The alleged offense was said to have occurred on Katonga Road in central Kampala, which falls under Central Division. The Chief Magistrate has the authority to preside over offenses committed within this area. Under this, the trial Chief Magistrate has the requisite jurisdiction to consider the complaint on oath filed by the respondent. Round 9. The Chief Magistrate separately consulted a purported parish chief, ward administrator, whose findings did not confirm the respondent's complaint and improperly relied on this consultation. Section 42, subsection 4 of the Magistrate Court Act provides that, I quote, for upon receiving a complaint under subsection 3, the magistrate shall consult the local chief. Emphasis. Magistrate shall consult the local chief of the area in which the complaint arose and put on record the gist of that consultation. But the complaint is supported by a letter from the local chief. The magistrate may dispense with the consultation and thereafter put that letter on record. The excerpt above states that upon receiving a complaint, a chief magistrate is required to consult with the local chief of the area where the complaint originated. This consultation is intended to gather insights or opinions from a local authority regarding the complaint. The magistrate must then document this consultation. The requirement for documentation suggests an element of transparency in how complaints are handled. However, it does not explicitly state that this consultation should be public knowledge. See Basaj Jabalaba versus Kakande, criminal revision case number 2 of 2013, reported. In this case, the chief magistrate complied with the law by consulting the ward administrator. Now, this brings me to the second question: whether the findings from the parish chief stroke ward administrator did not conform the response complaint. The record shows that the applicants attached a letter authored by M.S. Kabarungi Elizabeth, the chairperson of Katonga LC1 in Nakasero 1, and directed to the chief magistrate of Uganda Road to their complaint under oath. The contents of the letter were as follows. Quoted, my attention has been brought to a video recording with utterances by A1 Isaac Ssemakadde, the president of Uganda Law Society, insulting the person of the DPP. This is to confirm that the officers of the People Front for Freedom, where the incident is alleged to have taken place, are in my area or jurisdiction. The PFF occasionally holds functions where members of the press attend, including one held on the 18th day of November 2024. End of quotes. The record also indicates that, in compliance with the legal provisions outlined in Section 42, Subsection 4 of the Magistrate Act, the Chief Magistrate at Buganda Road issued a letter on January 14th, 2025 to the Nakasero 1 Parish Chief Ward Administrator requesting for verification of the claims made. Accompanying this letter was some correspondence from the LOC1 chairperson. The Chief Magistrate letter reads as follows. I have received a complaint on oath filed by Byamazima Joshua and Tony Tumukonde, alleging that A1 Isaac Ssemakadde, president of Uganda Law Society, insulted the modesty of a woman, A1 Lady Justice Jane Francis Abodon, the director of public prosecutions, when he allegedly referred to her as a vagina from Karamoja, while addressing members of People's Freedom Front, PPF, on 18th November 2024 at Katonga. The said utterances were recorded on a video. I also received a letter from M.S. Kabarungi Elizabeth, LC1 chairperson Katonga, confirming the said utterances. The same is attached. This letter serves to ask you to confirm as the area local chief whether the said allegations are true. In a response dated January 15th, 2025, the parish chief, ward administrator of Nakasero 1, Central Division, Kampala, confirmed that the statements were indeed made. She remarked, I quote, I hereby confirm that the letter dated November 21st, 2024 was written by Kabarungi Elizabeth, the LC1 chairperson of Katonga Zone, Nakasero 1 Ward, which is located in Kampala Central Division, and the stamp used belongs to Kampala Capital City Authority. She confirms that the utterances were made and all the contents of her letter are true, as per the phone calls made to her on 15th January 2025 at 13:21 hours. The above evidence indicates that the parish chief, ward administrator, confirmed the allegations utterances, confirmed the alleged utterances made by the applicant. In the response dated 15th January 2025, the parish chief, ward administrator, explicitly states that the letter from MS Kabarunji Elizabeth, the LC1 chairperson of Katonga, was authentic, and the claims regarding the utterances were true. Her letter also states she verified the truth of the alleged following a phone call to MS Kabarunji Elizabeth on 15th January 2025 at 13:21 hours. Considering this evidence, I find the parish chief, ward administrator verified the statements. Round 7 and 5. The chief magistrate added in holding that a prima facie case was established against the applicant under Section 115, Subsection 3 of the Penal Code Act, Cap 128, Laws of Uganda. The chief magistrate improperly found that the respondents met the reasonable and probable threshold under Section 42, Subsection 3 of the MCA. If a court sanctions a complaint under oath, it must be satisfied that it conforms to the law. Section 42, Subsection 5 of the Master Court Act states, after satisfying himself or herself that a prima facie, the commission of an offense has been disclosed, the key consideration is that before a magistrate orders a private prosecution, they must be satisfied that the complaint discloses a prima facie case. Jamil Damulira Mutuzi, an author on the subject of private prosecutions, underscores the significance of establishing a prima facie case prior to authorizing private prosecution, as articulated in the following statement. The question of whether a private prosecutor should have a prima facie case because he is permitted to institute a private prosecution has been addressed differently in different countries. In some countries, such as Australia, New South Wales, the existence of a prima facie case is one of the requirements that have to be met before a person may be permitted to institute a private prosecution. The rationale behind this requirement is to prevent people from abusing their right to institute a private prosecution. As the Tanzanian Court of Appeal held in Edmund Mujegwa and 6 others versus John Mugaya and 4 others, Criminal Appeal number 18 of 1999. In all applications of this kind, unless the magistrate judiciously applies his mind to all the circumstances in which to grant leave for private prosecution, the danger of victimization and abuse of process is imminent. The essential ingredient of the offense is one such factor that should not be overlooked. Turning to the instant case, the chief magistrate was alive to the requirements of Section 42, Subsection 3 of the Master Court Act. On page 6 to 7 of the ruling in Uganda, private prosecution by Yamazima Joshua and Tony Tumukunde versus Isaac Kimaze Ssemakadde, criminal case number 913 of 2024, is stated as follows. The prima facie case under Section 42 of the MCA is for court to establish as to whether the commission of an offense has been disclosed and that the complaint is not frivolous or vexatious. The complainant alleges that the alleged utterances amount to an offense under Section 115, Subsection 3 of the PCA. Section 115, Section 3 of the Penal Code Act states, any person who intending to insult the modesty of any woman or girl utters any word, makes any sound or gesture, or exhibits any object, intending that word or sound shall be heard, or that the gesture or object shall be seen by that woman or girl, or intrudes upon the privacy of that woman or girl, commits a misdemeanor and is liable to imprisonment for a term of 1 year. For a prima facie case to be made out with regard to the offense of insulting the modesty of a woman, the following ingredients must be seen to exist. 1. A person utters any word, makes any sound or gesture, or exhibits any object. 2. He or she does so with intent that that word or sound shall be heard, or that the gesture or object shall be seen by that woman or girl, or intrudes upon the privacy of that woman or girl. 3. The intention to insult the modesty of any woman or girl. 4. It is the accused person who uttered the said words, or who made the said sound or gesture. He further stated, the evidence before this court is of a flash disk with a video of the alleged utterances attributed to the intended accused, and a transcription of the same, of which both were annexed to the complaint. I have had the opportunity to play the said video on the flash disk. I have also read the transcription of the utterances on the said flash disk made by Uganda Broadcasting Corporation. In the said video and transcription, a male voice is heard saying all these words like your particular carefully is then given legal addressing by this from Karamoja. I have made a case before that you have a pumpkin of a DPP, but some lawyers continue to pretend that is actually a DPP, and for some they take it very seriously because they think it is an attack on womanhood, or it is an attack on being a Karamojong. That's an absolute nonsense. It is a pumpkin. It is dead wood. It is a dim wit. It is a carist, shameless, carist. It is a chuko in the nest of our criminal justice system. The male voice in the above court was referring to a DPP, to a director of public prosecutions. Uganda has one DPP, Honorable Justice Jane Francis Abodo, who is a woman, and she comes from Karamoja. It is most likely that she is the person referred to in the above video. In the said video, the male voice is heard referring to the DPP, a woman, as a vagina from Karamoja, a pumpkin, deadwood, etc. In their primary meaning, the above words are offensive, and if directed to a woman, they amount to insulting her modesty. It follows, therefore, that whoever made such utterances at a public gathering in the presence of media intended that Honorable Justice Jane Francis Abodo would hear the said utterances. Anyone who refers to a woman by her private body parts intends to insult her modesty. Anyone who refers to a woman as from Karamoja, Deadwood, etc., at a public gathering, well aware that there is a media presence, know that the said woman will definitely hear those words against her. The intention is most likely to insult her modesty. The person in the video has been identified as Isaac Kimaze Ssemakadde, the president of Uganda Law Society. When his advocates appeared in court on 4th December 2024, they did not dispute the allegation that it was their client in the video. Their argument was that Honorable Justice Jane Francis Abodo had not complained, yet in this case is victim-centered. The victim, the evidence on record is, as alluded to in the Chief Magistrate Court ruling, indicate that prima facie, the necessary elements of the offense of insulting the modesty of a woman were established. Below is the breakdown of how each ingredient is satisfied. Utterance of words, sounds, gestures, or expression of objects. There is evidence that a person uttered derogatory terms and phrases directed to a woman in a video recording. So, intent for the words or sounds to be heard. There is every evidence that the remarks were made at a public gathering with media present. The setting and presence of media indicate a clear intent to broadcast those statements beyond a private conversation. The strategic choice to articulate the remarks in a forum where they would be recorded and disseminated underscores the likelihood that the accused sought to express his views and ensure they reach the victim's ears. The intention to insult modesty. When given their ordinary meaning, the language used is offensive and demeaning and serves no constructive purpose other than to inflict emotional harm and degrade in a public setting, whoever they intended for. For, accused as the originator of the remarks, it has been established that Isaac Kimaze Ssemakadde is the individual making the remarks in the video, and his advocates did not dispute this identification in court. The Chief Magistrate accurately concludes that a prima facie case for the alleged offense was established as all essential elements were evident. I will now deal with the issue of reasonable and probable cause. Section 42, Section 3 of the MCA provides that a person other than a public prosecutor or a police officer who has reasonable and probable cause to believe that an offense has been committed by any person may make a complaint of the alleged offense to a magistrate and has jurisdiction to try or inquire into the alleged offense, or within the local limits of whose jurisdiction the accused person is alleged to reside or be. Every such complaint may be made orally or in writing, signed by the complainant, but if made orally, shall be reduced into writing by the magistrate, and when so reduced, shall be signed by the complainant. This section empowers individuals, private citizens, to prosecute crimes they believe have occurred. It specifies that any person, except for public prosecutors or police officers, who believes an offense has occurred, has the right to make a complaint. The individual, however, must have reasonable and probable cause for believing that an offense has been committed. It does not matter whether an individual is the victim or not. All that is in, all that is the said individual is required to have uh, legitimate reasons or evidence.
No, no, securing evidence. Whether that is the ruling for the state of execution or the main application, which is provision. Number 30 is the application.
I'm reading, as I said at the beginning. Were you not hearing? You'll check the record after.
Okay.
Don't disrupt court. This section empowers an individual, private prosecutor, private citizen to prosecute crimes they believe have occurred. It specifies that any person, except for public prosecutors or police officers, who believes an offense has occurred has the right to make a complaint. The individual, however, must have reasonable and probable cause for believing that an offense has been committed. It does not matter whether an individual is the victim or not. All that the said individual is required to have are legitimate reasons or evidence to suspect that a crime has taken place. The operating phrase in the above section is reasonable and probable cause. In Aminan Pindi versus Ramadan Kiwe, probable and reasonable cause was defined as quoted, an honest belief in the guilt of their accused, based on a full conviction, founded upon reasonable grounds of the existence state of circumstances, which, assuming them to be true, would reasonably lead an ordinary prudent and conscious man, placed in the position of the accuser, the conclusion that the person charged was probably guilty of the offense imputed. The phrase reasonable and probable cause means the individuals should have legitimate reasons or evidence to suspect that a crime has taken place. This requires more than mere suspicion. Some level of evidence or support for the belief is necessary. In the instant case, the private prosecutor presented evidence alongside their complaint, specifically a flash spread containing a coding of the alleged utterances contravening Section 115, Section 3 of the Penal Code Act, and a transcription from the Ghana Broadcasting Corporation. The Chief Magistrate Judicial considered the statement under oath and consultation with the ward administrator and found that the complainant had made the expression of a reasonable and probable cause before ordering the prosecution. Round 10 and 11. The Chief Magistrate wrongly found the response complaint was not vexatious and frivolous. He argued in holding that the respondent's complaint was not an abuse of court process. Section 42, Section 5 of the Magistrate Act provides, after satisfying himself or herself that prima facie the commission of an offense has been disclosed and that the complaint is not frivolous or vexatious, under this ground, the court is more interested in the phrase and the complaint is not frivolous and vexatious. This part of the section is that the complaint should have merit and not be based on unsupported accusations or intended merely to cause trouble. It is after supporting this application, the applicant asserts that the respondents have initiated several lawsuits against him in bad faith, clearly misusing the court process, and in flagrant abuse of court process, seeking to further harass him by commencing a baseless private prosecution. The fact that a private prosecutor is bringing proceedings or civil proceedings are concurrent or remain an option and irrelevant consideration, save where improper motive is concerned. Final choose in private prosecution to raise the issue of the improper motive of the prosecution or prosecutor. They should ordinarily be able to establish that 1. The private prosecutor is pursuing a personal vendetta against them. If instituted, the civil suits are in a way related to the criminal one. 3. The prosecution is purely how to achieve financial redress rather than a means to obtain punishment for criminality. In the instant case, I find no evidence on record demonstrating that the private prosecutors have personal vendetta against the applicant. I also find that the applicant has not proven that his prosecution is solely motivated by the desire for financial redress rather than to obtain punishment for criminality. Through his pleadings, I find that the response have filed 2 civil matters. However, although these 2 matters are civil, they are not connected to the criminal matter filed by the respondents. These civil matters concern the expulsion of the Attorney General and Solicitor General from the Uganda U.S. Council via Order RNB number 1 of 2024. The current criminal matter involves insulting the modesty of a woman. The applicant claims that the matters were withdrawn but provides no evidence. If the 2 matters are still in court, the civil court will determine whether the response had the necessary local standard to file those matters. In doing so, the issue of whether the rigorously abuse the court process will be adequately addressed. If they were withdrawn, as suggested by the applicant, he's welcome to seek damages in the civil court for malicious prosecution. What this court will not do is to infer abuse of court process without concrete evidence. Round 2. The Chief Magistrate improperly failed to dismiss a denied complaint on oath by the intending private prosecutors. The scenario that gave rise to this ground can be likened to a witness giving evidence in chief, being cross-examined, seeming to contradict themselves, and offering clarification during the examination. Paragraph 5 of the affidavit in support of my criminal examination was 87 of 2024 states, I know that on 22nd November 2024, a cantankerous couple of mischievous advocates, Yamazima Joshua and Tony Tumukundi, filed a complaint on oath seeking summons for my appearance to plead to a proposed charge of insulting the modesty of a woman, to it, M.S. Jane Francis Abodo of Karamoja. Contrary to Section 115, Subsection 3 of the Penal Code Act. In paragraph 7 of the affidavit in reply, Joshua Yamazima upon what seemed like a denial of the complaint of oath, if read in isolation of the entire affidavit. The deposition stated that the contents of paragraph 5 to 26 of the applicant's affidavit are denied in total, and the applicant shall be put to speak proof thereof. However, if the entire affidavit is read, it becomes clear that the complaint on oath was not denied. Paragraph 9 states, I know the complaint on oath in KLA 00CRC4 0913 2024 is competently before the court, having complied with all the preliminary requirements. And of course, I find that Joshua Yamazima did not deny his complaint on oath. Despite what might appear to be a denial when looked at in isolation from the entire affidavit, In paragraph 7 of the affidavit, in reply, Joshua says that he denies the contents of the applicant's affidavit, including the complaint in total, which would be interpreted as denying the complaint. However, when taken in the context of the entire affidavit, including paragraph 9, it becomes clear that he acknowledges the existence of the complaint, of course. He explicitly saying, I know the complaint composed in KFA, that's 00, that's CR, that's CO, that's 0913, that's 4. The respondent is, in essence, indicating that they know the particulars of the small complaint, relatively, that's the case number already, the matter involving legal allegations or claims. In saying, he is competent before court. The respondent argues that the complaint has been adequately filed according to legal procedures and is under the Constitution. So, while he may deny the specific allegations or claims outlined in the application, it does not deny that the complaint exists and is legally in the court system. Round 6. The Chief Magistrate disregarded Section 6, Subsection 2A, 7, Subsection 1, and 2, and 4 of the Electronic Transactions Act in considering the response video evidence. For ease of reference, I will reproduce the law. Section 6, Section 2A, Section 7, Section 1, 2, and 4 of the Electronic Transactions Act, Cap 99, provides. Without going into the merits of the case, ensure that electronic communication can be organized and evaluated in judicial proceedings is essential. So, when does the electronic evidence become admissible? During investigations or trial? Electronic evidence is admissible when it is authenticated and meets the rules of evidence, typically at the trial stage. During the preliminary phase of the private discussions, evidence is used to establish the prima facie case, meaning it must raise a presumption of fact unless contradicted by other evidence. This evidence does not need to be conclusive, but should provide a reasonable basis for the claims made. At this stage, the focus is on whether sufficient evidence exists to proceed rather than securing a conviction. In the current case, since the trial had not commenced, the Chief Magistrate was not required to adhere to the admissibility criteria for electronic evidence. His only obligation under Section 42, Section 5 of the Magistrates Act was to determine if the available evidence would raise the presumption of fact, which he successfully fulfilled. Ground 8. The Chief Magistrate did not consider the context, symbolism, and constitutional protections of the words in question, thereby occasioning a miscarriage of justice. I will first deal with the issue of failure to consider the context and symbolism of the words in question. The first, often considered the primary rule of interpretation in literal rule, is the literal rule. Under this rule, words are interpreted based on their plain, ordinary meaning, without developing into other excesses like context, symbolism, intent, or purpose. When using this rule, The court's only role is to ascertain the meaning of the words in their common, everyday sense, rather than with specialized or technical meaning. In the instant case, the government must follow the first rule of interpretation, as seen on page 7 of his ruling by criminal case number 913 of 2024. I quote, in the same video, the male voice is heard referring to the PPP, a woman, as a vagina from Karamoja, a pumpkin, dead wood, a dim wheat. In their primary meaning, the above words are offensive, and if directed to a woman, they amount to something of modesty. In my view, I find that even an ordinary bystander, having given the words in question their ordinary meaning, would have come to the same conclusion that the words were offensive. If the applicant wanted to benefit from the other two rules of interpretation, the golden rule and mischief rule, would, if himself to appear before the court when summoned, and if put on a defense, explain the context and symbolism of the words in question. Then, the females to express their diverse opinions. While females to express their diverse opinions. While freedom of expression is a core aspect of the Ghanaian society, it is not without its limitations and restrictions, particularly regarding national security, public order, and the rights of others. See Article 43 of the Constitution. Several laws in Uganda regulate the landscape and activities related to freedom of speech. Therefore, speakers must understand the boundaries set by law before engaging in any speech. Of suspicious interest in this case are Article 43, 1 and 2, Part C of the Constitution, Article 24 of the Constitution, Section 115, Subsection 3 of the Penal Code Act. Article 43 is reproduced, Article 24 is reproduced, and Section 115, Subsection 3 is reproduced again here by the land judge. When read together, the above provisions of the law show that while individuals in Uganda are entitled to speak freely, the prevailing legal environment indicates that such freedom exists within a framework of caution and complies with the complex web of laws meant to protect various interests. In this particular case, within the context of their ordinary meaning, dehumanizing words which serve no constructive purpose other than to inflict emotional harm and regret were allegedly said in a public setting with the media present. The words were directed to a woman. The remarks, having been allegedly said to a public gathering, at a public gathering with the media present, indicate a clear intent to have the statement recorded and disseminated with a likelihood of reaching the victim's ears. Considering this, the applicant could, on the face of it, be said to have committed a misdemeanor under Section 115, Section 3 of the Recusal Act. And contravened Article 43 of the Constitution by violating the fundamental human right of the woman he is alleged to have insulted, that are also protected under Article 24 of the Constitution. For the court to regard the said words as protected, it must evaluate whether they fit within the acceptable and demonstrably justifiable category as outlined in Article 43 2C. Determine whether words are constitutionally protected is inherently contextual. The court cannot indiscriminately classify any words or particularly those deemed offensive as constitutionally protected without proper context. The applicant has failed to provide this necessary context despite being called upon. Consequently, he cannot fault the chief magistrate for not recognizing them as constitutionally protected. Counsel, my duty is to pronounce the ruling, and you are allowed.
Our we intend to arrest the person because he has
before the trial judge, my duty is to pronounce it, and I pronounce it. Don't disturb.
Your worship, I'm not disturbing.
Round 3. The chief magistrate erred in law by denying the applicant's request to cross-examine Yamazima on his affidavit in reply. Get to know that this, I'm just a registrar assigned to perform a particular duty, and it must be done. It's my duty. Once I fail, I have failed myself, and I will not sit as a registrar. So, abide by that. The rest, you continue with the trial judge. Okay? The right to cross-examine witnesses, including a private consultant, is a fundamental aspect of a fair trial, ensuring that the accused can challenge the evidence presented against them. However, under Section 1 of the Evidence Act, cross-examination of an affidavit in reply is at the discretion of the court. Section 1 of the Evidence Act provides that this act shall apply to all judicial proceedings in or before the Supreme Court, the Court of Appeal, the High Court, and all courts established under the Master Court Act, but not to affidavits presented to any court or officer, nor proceedings before an arbitrator. The Act is intended to govern the proceedings in specified courts while excluding certain legal documents, affidavits, and alternative dispute resolution processes, arbitration. By virtue of this, the court may exercise its discretion to allow cross-examination depending on particular factors of each case. Some of the things the court can consider before exercising its discretion include the following: 1, the nature of the case; 2, whether cross-examination will actually delay the trial or facilitate expeditious disposal; 3, whether the deponent of the affidavit contains facts that are in issue or conflicting evidence. 4, if cross-examination will assist in resolving the issue before the court. In the instant case, the response are said to have denied their complaint of the chief magistrate in his ruling by the Commissioner's application number 87 of 2024 following that once the 10 paragraphs of the said affidavit are once the 10 paragraphs of the said affidavit are read together, Joseph Yamazima cannot be found to have denied filing the complaint. Herein, I have agreed with this finding and the subheading round 2. In my view, the examination would only unduly delay the trial and would not have facilitated the expeditious disposal of the matter. It, therefore, did not warrant the court to exercise its discretion. Round 4. The chief magistrate wrongly concluded that there was no breach of the duty of candor by the respondent. Paragraph 9 of the applicant's motion, by the criminal statute number 87 of 2024, states that the respondent did not make frank and full disclosure to the court and the investigative and prosecutorial authorities. Additionally, paragraph 15 of the affidavit in support by the criminal statute number 87 of 2024, the applicant avowed that the cantankerous couple unjustifiably deprived me of an opportunity to confront the alleged victim on the ingredients of the proposed offense before an independent investigator, thereby violating my constitutional right to a fair pre-trial investigation. I recognize that the legal framework for private prosecution is unclear and well developed. This may change an accused person's right to a fair hearing and Article 44, Section Part 4 of the Constitution. Part C. It may also hinder a prosecutor's right to successfully prosecute a clever accused person who exploits these loopholes to their advantage through unnecessary endless objections. In light of this, I find this issue deserving of revision. This would enable the court to interpret the various problems arising, including disclosures in private prosecution. When are they made? What can be disclosed, and to whom are they made? 2. The right of prospective accused person in private prosecution. 3. The roles and duties of the private prosecutor. 4. The role of the victim. Ground 12. The chief magistrate improperly declined to recuse himself from the proceedings. The applicant contends that the chief magistrate should have recused himself from the trial. The record shows that the chief magistrate considered the request to step down and dismissed it for lack of merit. In light of all the above, except for ground 4, which touches on the right to a fair hearing, I find that the main grounds for revision fronted by the applicant do not raise legitimate issues with a reasonable chance of success if brought to a full hearing. By virtue of ground 4, the applicant has established in my first case whether the applicant will suffer irreparable damage if the application is not granted. The applicant contests that he will suffer irreparable harm and prejudice by undergoing a trial that is prima facie reshaped by fundamental flaws in irregularities. The applicant further asserts that the circumstances have exposed him to adverse publicity, damaging his status, profession, and livelihood, and threats of arrest, detention, conviction, and sentencing of the charge he maintains is unfounded, illegal, defective, and unsustainable. Conversely, the respondent argues that the applicant has failed to demonstrate that he will suffer any loss or injury and cannot be compensated through monetary damages, nor has he shown that such harm is difficult to quantify. This court is in doubt as to whether or not the law shall be irreparable. Considering this, I find that the applicant has failed to prove this ground. Whether the balance of convenience tilts in favor of the application being granted. This fundamental principle is only considered if the court is in doubt of both ON over the first two requirements. Having found that the applicant has a prima facie case, but the court is in doubt as to whether or not they will suffer irreparable loss, the balance of convenience must be considered. To achieve this, and weigh the potential inconvenience to the applicants against those of harm to the respondents if the stay is granted. Firstly, the applicant argues that proceedings with the lower court's prosecution without a stay would lead to a situation where if the revision application is ultimately upheld, the applicant would be left with a position where their rights and liberty are being impacted unnecessarily. The argument emphasizes preserving the status quo until the revision application is resolved. On the other hand, the victim and the accused deserve justice. All must have their day, and the accused deserve justice. All must have their day in court without unjust or God blocks. Secondly, the applicant highlights the importance of safeguarding personal liberty, which is the fundamental principle of law. By granting the stay, the court protects the applicant's rights, ensuring that any adverse actions taken by the lower court are reviewed and assessed for validity. On the other hand, the respondents emphasize that halting proceedings will have serious ramifications on the proper function of the justice system, potentially affecting public confidence in the rule of law. Third and last, the applicant argues that allowing the lower court to proceed will result in irreparable harm to him if the findings were annulled later. A stay would mitigate this risk by halting proceedings while revision is promptly conducted. The applicant is basically arguing that if the lower court continues with its proceedings and makes findings that are later overturned, it could lead to significant and irreversible damage to him. Therefore, he believes that granting a stay is necessary to prevent this potential harm while a review of the case is conducted. On the other hand, the respondents argue that if the stay were conducted, they would subsequently suffer loss of their rights to prosecute. They may not be able to recover damages sufficient to compensate for the full extent of their loss if they wanted stay of proceedings pending revision application were found to be unwarranted. Unlike the malicious prosecution remedy available to the applicant, the respondents argue that granting the stay would potentially harm their rights to pursue prosecution and that they might not be able to fully recover damages for their losses if the stay is deemed unnecessary. The situation contrasts with the applicant, who can seek a remedy for malicious prosecution. In the scenario presented, the balance of convenience leans towards the applicant for several reasons, despite the validity concerns raised by the respondents. The reasons in favor of the granting include: 1. Preservation of the status quo. The applicant emphasizes maintaining the status quo until the revision application is resolved. This argument underscores the need to prevent the potential violation of the applicant's right to liberty that could arise from continuing the lower court prosecution. 2. Judicial integrity and the rights of the respondents. While the respondents raise important points about the potential hindrance to their legal rights and the judicial process, these concerns are primarily about the implication of delays and the judicial system's efficiency. However, the more pressing issue is the protection of individual rights, especially when those rights may be jeopardized. The response claims of harm do not carry the same immediacy or risk of damage compared to those of the applicant concerned. In the interest of justice, I find it justifiable to grant a stay to safeguard the applicant's right to liberty while the revision is underway. This would ensure a fair process for both parties without the threat of serious consequences. Decision. The application is allowed for the following reasons. The applicant has established a first case. 2. Balance of convenience is in favor of the application being granted. Orders. 1. The Chief Magistrate of Uganda Bill of 2024, pending determination of Isaac Ssemakadde versus Uganda, private prosecution by Mazima Joshua and Tony Kundi, criminal revision case number 002 of 2025. The parties are directed to file submissions in the criminal revision case number 2 of 2025 to expedite the response must file their reply by 2nd May 2025. And the rejoinder must be filed by 7th May 2025. The court will issue its ruling or not. Signed, Gardenia, Paul, Wariba, Judge, 12th April 2025.
Everywhere. Around B.
Anyone has a license anything after that? No. What's what they say? Look at that, see copies. They are already
Everywhere.
R&B.
R&B.
Everywhere.
Everywhere.
third judge is I never partake this matter. As is the set to go and serve in another jurisdiction. For that reason, we have found a man to the second of May 2025 when the third judge will be available.
Aminat. Council, tugende wali wansi. Council, tugende wali wansi. Kote ekyagenda maaso. Bajalowooza tuli.
Slope down. You want something on march.
Eno yekola emirimu gya Isaac Ssemakadde. Togiraba Council. Yegisobola.